So thank you all for spending your time here with us. We are Yellow. We are an India-based legacy, estate, and succession planning firm. We're a one-year-old company. We're trying to change the way Indians look at will making, succession planning, and safeguarding their legacy, as well as helping their future and their families. Manisa, if you can just move next. So today, what we would cover are, while we will talk about our offering a little later, relevant to you as a Bahrain-based NRI audience, we will keep it more towards an awareness. We want each of you who are, who strived a lot to build wealth for your families, who've been involved in a lot of wealth accumulation and asset management cycle, to also understand the importance of wealth transfer as a final leg of our wealth journey as such. And some of the elements that involve or included in this aspect of wealth transfer to our future, we call it legacy or estate planning. We will cover that in some detail. The first step towards an effective estate plan is having a formal legal will in place. We will talk about that. We will also talk about typical superstitions that stop people from making a will, some of the myths we will try to debunk, and we'll give you some specific facts, including some case studies, which will give you a lot of points before you consider making your will, either with us or through any channel as you deem fit. But the idea is to inculcate the importance of creating a will as a first step towards your financial wealth transfer and legacy planning journey. We'll also have a little bit about Yellow that I talk about, and please feel free to add all your queries on chat as well. We will also have a Q&A session post the presentation. We could do both. Next, Manisa. So here is a very important point in terms of who all needs a will or who all can make a will. In India, at least, as long as you're a major who has 18 plus, if you are married, if you have any kind of asset, it could be something as small as a basic bank account, some investments, some property. You don't have to be a HNI or ultra HNI to have a will. And it's very, very important for people who have dependents or minor children, because the way you choose your guardian in case of something going awry or something in case of an unfortunate incident is very important. So basically these are all candidates for having a will. But that said, can any of you answer what is the level of penetration of wills in India? Some percentage that any of you can either put on chat or mention on call. We'll see if you are close to that.
Less
The
than
actual
1%.
numbers. Absolutely. Hardly 1%. Thanks for that, Manisar. And can you also give an idea of how much it would be in, say, a developed nation like the US?
30 plus.
Perfect. 35 to 40 at least. So in US, basically the idea of having a will, they call it a living will, and pretty much most people who have some wealth in place have a will, because they're very practical in nature. They know that having a will ensure that their future, their family can easily identify all that they've built over time. Whereas in India, there is that taboo or a idea of it's a morbid, untouched topic. Let us not get into that. As long as we are alive, what is the problem? Why should we have a will? So that is the mindset, which is the reason for this low penetration in India. Next, Mani sir.
மணின்னே சொல்லுங்க
சரிங்க, okay, man. And it's getting recorded also. So Mani, and for everyone here, and I was talking about wealth creation being the first stage of a wealth planning. We also are Indians are very good with wealth management as well. So I know Mani himself, Lakshman himself are propagating a lot in terms of savings, investing. You're talking about NPS as a structure. I've seen a lot of those forward. So I know that all of you in your group have spoken a lot about creation of wealth through multiple channels, managing the wealth effectively. Now the last stage, where we come into play, is the protection and transfer of wealth, and which is where wills is a small element of the journey. but where we are getting into is to say that start with a will, but also explore options which will give you the best way to have your families get what they truly deserve in case something goes wrong with you. Next. After this slide, I'll pause to take some questions, but these are points for you to think about and very pertinent. In case of not having a will, or in case of not planning for the future and managing your wealth, in India, we call it intestate succession. So basically, this is a legal term which means that the succession laws which are governed by the religion we practice, be it a Hindu or a Christian or a Muslim, come into play in case a will is not formally done. What that leads to, so the succession laws, for the lack of a better word, these are all old school and archaic, at least 50 to 100 years back in time. So I'll take my own example, and Lakshman might be aware of this as a friend of mine. I have a special brother. So in my case, my will, my thought process is that at least 50% of some of my property should go to my brother, because he is differently abled and he will need support with the help of a guardian. But what the Hindu law, if I don't have a will make it is that all my wealth will only go to my wife and kid, which is not the ideal situation for me as a person. Same could be the case for many of you, where not necessarily you would want all your wealth to go only to your mother or wife. You might have other family members whom you'd want to bequeath your wealth to. So in these cases, to ensure that we overcome the succession law, a will is the first step. Now, other elements that come into play, family disputes, and these could be something that many of you have faced internally as well, or at least you would have heard about how wealth comes into the way in terms of, if a person predeceases the other family members, how they fight over it, and the disputes that happen within siblings over a father or mother's wealth. Another element, and especially considering you as an NRI audience, is that in the case of an individual not having a will and passing away, while you might be the official legal heir, there are many times where a legal heir certificate is required, and the process is very strenuous in terms of even getting what is rightfully yours. If only these individuals had a will in place, it would make it much easier for the family members to identify where their wealth has been created for them, as well as go through these processes in a much easier way. So while it would still involve some amount of paperwork, at least that initial aspect of identification of assets is much easier when a will is in place. And it will also ensure that nothing slips through the cracks. There would be minimal monetary losses for the future generation if a will, which is not just an individual's wishes and vision, but it also, you can think of it as an asset register, which will highlight and identify anything and everything he or she has built over time. So these will ensure that there are very minimal monetary losses because everything is easily identified, and how to go about getting your what is rightfully yours. There are a few more slides that we wanted to cover, but I'll just pause it here to see if you have any questions, either on chat or you could ask it now. And I'll have Nikhil answer those. Just to add, Nikhil's been, I think it's a poor network he's taking it from, which is why I am doing more of the talking. But he is our co-founder. He's a CA by qualification, and he's been in the space of wealth and asset management, and especially the estate planning. His last role, he was with IAFL managing typically the ultra HNIs and HNIs and their wealth. So his inputs would be very valuable for you, because it's his idea to bring this to the masses, to say that wills and legacy planning should not just be for people who are ultra rich, but it should propagate to any and every Indian who has an asset in India. So please feel free to have your questions post. Nikhil will be happy to answer them.
I have one question, but it is not related to the topic. It's somewhat as a startup company. How did you get this idea that you want to create a will as a in that space, like digitalization? How did you get that idea, and the main reason? Is there any main reason?
No, so answer is very simple. like Prashant said, what I used to do earlier was cater the same set of services. Of course, not only will, but look at much more complex estate planning structures for ultra HNIs or high net worth individuals and ultra high net worth individuals in India who have family situations in India, outside India, large assets or businesses, how to plan for their current situation, ring fence from potential liabilities, etc., and how to seamlessly transfer that to future generation without too much loss in whole transmission. That's what I used to do for larger families, but realized the some of those staggering facts which will come in the next slide is also kind of made me realize why not explore this to the larger market. Second, also for the fact that it's very less penetrated and somebody has to take that challenge. Thought why not try out and give this out to larger public, because not that larger public doesn't have access to services like this. It is through more unorganized and through lawyers, etc., who are doing it, but you don't get it's not that you get the right output and the right quality of document that should either way come to everyone. And to make it more affordable, more secure, and easily doable by everyone, and not spend time visiting lawyers, getting this done, and all of it, and instead do it at the comfort of your home, we realize going technology route is the only way to do this, and that's the only way we can touch mass market, right? As in, otherwise, I as an individual have 24 hours. How many people can I meet on a day-to-day basis?
Yeah, that's a great idea because even for my case, I was 2 years back. I was trying to create a will. I was approaching 2 3 people, one CA and other people. Anyway, at the end of the discussion, I did not get confident to go with them. One point of view, and the information also not clear. Then
Right.
when I saw this post from Prashant in the LinkedIn, so I just started to talk with them. Then I got the clarity. So it was very easy. I will say the app is very good from one point of view.
Thank you.
Yeah.
Thank you.
The
All,
second-
all, all that we have tried to do, at least this is the first version of the app. All that we have tried to do is that, to the extent possible, I've tried to mimic how I would have in person met a client, right? To give
Yeah.
those contextual help to ensure you can do it on your own. But at any point in time you want to speak to a lawyer, we already have team of lawyers on our roles who you can get in touch with to get more answers.
Yeah.
Prashant, the basic doubt is we heard about the settlement document and will. So, what is the major difference between settlement document and will? And which is a superseding or which has to be created by as a self?
So, I'll pick up this question.
Sure.
Settlement document, very honestly, is more prevalent in Tamil Nadu than if you look at any other jurisdiction. I'll tell you also why, is because gifting in Tamil Nadu had a higher stamp duty. So the loophole towards that was that you create a family dispute and do a settlement, and with that the stamp duty came down to 25,000 rupees to transfer the asset, right? So that was how settlement document become very prevalent in Tamil Nadu. And that being said, now gifting in Tamil Nadu also has been aligned to things. So settlement document is kind of reducing more or less now. But that being said, as an estate planner, if I were to advise, what you're doing through a settlement document or a gift deed is that you're giving away assets during your life and losing control. And what happens if tomorrow you need access to those assets? Will the person who you're gifted to or settled to will help you out? Everything is good in a family situation, but when money comes onto the table, there is always a doubt around what will happen and what cannot happen. Simple situation or a case that I can talk about from a gifting standpoint itself is, you'd have heard of Vijayapad Singhania, who was the chairman of Raymond's Group. and he had a situation where he thought things are not going good from a health standpoint, and he gifted all his assets to his son. And things went differently for him. He recovered completely well, but son turned the other side and said, you figure your stuff way in terms of how you want to live, but I'm not going to give back any assets, and I'm not going to take care of you.
So
Right? You don't want to come into those situations. The beauty of a will is that it comes into effect only post demise, not during life.
understood. So you have the full
During life,
control.
you have complete control.
You have the full control till end of the day. But in the settlement,
Correct.
once it is done, it is done. Like the asset
It
is
is done.
already transferred, so we don't have any control over on that.
Absolutely. But of course, it'll be completely wrong from my side to not give you the complete picture. There's another way we can actually get this done. There's something called as you can gift with retaining life interest, which would mean that you have asset today. You can gift it to your family, but you can always have a clause in the document to say that until I am around, say for example, it's a rented house, or rather a house given out for rent. You can say that I have life interest on that property, essentially to say that all benefits arising from that property comes to me during my life. You get complete access only when I'm not around.
Okay.
That's an option available.
In the settlement also.
It's not. It's more a gifting with the retaining life interest is what it is called. You can do that.
Okay.
Wherein if I have a property to say that tomorrow nobody can evict me from that property because I have the right to stay or I have the right to get benefits out of it. But the person who I have gifted to cannot sell this property without my consent because I still have life interest. But when I'm not around, because I'm not around, the person who you have gifted to has complete access to the asset.
Okay.
So Nikhil, just a leading question there on your point. What are the advantages of this option or the other way compared to
that works only for
somebody choose this?
That only works for immovable property, not for other assets. Because for other assets, you can't do any of these options of gifting with life interest. For the other assets, if you gift, you've lost control.
Okay.
And therefore, you need to create a structure. Either do it through will, which would mean that it passes post-demise, or you could look at advanced structures like a trust, where you can create a trust, park the asset there. You can determine how these assets need to be distributed. When during your life, post your demise, should it go immediately? Should it go when your children have attained, say, 25, 30 years? All those options are available. Simple document to ensure transmission happens in a very simple fashion is creatable. That doesn't kind of let go of control from your hand, and your wishes are clearly captured.
Okay. Vipul, do you have any doubts? Vipul, any other guest, do you have any doubts? You can raise it.
Yeah, this is Raghavan here.
Yes, Raghavan.
Okay, so I have a clarification on the will part. So you told the difference between the will and the settlement. So if somebody, as you mentioned, you use the living will format. So the living will, is it like once if it is given, does it come into effect during the life or after the life?
So there's no concept of a living will for India.
Okay.
Living will as a concept is available probably in the US.
Okay.
In India, living will as a concept is not valid. In India, will comes into the picture only post demise.
Okay.
If you want to create something like a living will, then that can be effected through a trust.
Okay, so simply put, if I write a will and that will come into effect only after the demise of the person.
Correct. And I kind of get where you're coming from. Is that if you write a will, is it sacrosanct? The answer is no. You can write any number of, you can make amendments any number of time, and the last will that you put together is the final will that gets effect to. So your
Okay.
wish could be different in each and every will, but the last will is what is considered always.
Okay. All right. Just one more question.
Sure.
Yeah. So, the next question is: imagine if the head of, maybe the husband is writing the will to his son, and husband is no more, and but the wife, wife is there. So what happens? Like after the husband died, so the ownership goes to the children's, or till the life of the wife, the will still still hold on to the to the wife's name. How that is?
No, so are you saying that if I write a will where I say assets go to my spouse and post my spouse's demise it goes to children? Is that what you're saying?
No. Imagine like a person A is writing a will. After his demise, his properties goes to his children, but the person A died. That is the primary owner is died, but the spouse is still alive. In that case, how it works?
So two scenarios. Scenario one is that if the children are major, then the assets go straight to the children. Because your wishes are saying that it goes to children, it goes straight to the children.
Okay.
Right? Scenario two is if the children are your minors, then the minors can't hold the assets in their name. Then it gets held in the name of the guardian until the child turns 18 years.
Okay. All right. I have two more questions. Sorry for that.
No problem. We are more than happy to answer. We are here to only answer questions.
Okay. So the second is, so if a person A is writing the will, so the person A has to write that after my life, the property will go to my spouse, and after her life, then it goes to the children. Can we write it like that?
You can write it, and that can work only if both of you are not around.
Okay.
But once the asset goes to spouse,
Okay.
the transfer has happened.
Okay.
Thereafter, you can't have conditional transfers. Just to give an example,
what you're saying is you cannot make any amendments to it. You can only hold it and then pass it on.
No. What I meant to say that if I write a will, where I say all my assets needs to go to my spouse, that is a valid wish.
Okay.
But I can't say that my spouse has to hold it further and give it to my children. That's not a valid wish. Because once I transfer the property to my spouse, post my demise, assets has gone to her name.
Okay.
He's a rightful owner of the property. Now you can't have conditions saying that it has to go to children.
Okay. So we cannot have an options like after my life it goes to my wife, and after her it goes to my children. So
no, you can't have that right unless your wife also has the same wish. Then yes, it works. If she has a different wish, the answer is no. It will never go to child.
No. I'm just asking on a positive scenario. The person, the husband and wife, both are taking up a decision that after the husband's life, the control of the property goes to the spouse, and after her life, then it goes to the children.
No, you can't have such conditional transfers. Through a will you can't. But you can, if that is a specific wish, then that can be effected through creating a trust.
So Nikhil, just to add there, I think Ram, right? Or sorry, I missed the name. So basically, in this case, it is a case for each of them to have a will. The husband to say that post his demise, his wish is for it to go to his wife, and the wife to mimic it by saying that after her, she having her own will, saying that post her demise, the wealth and the beneficiary son. So that's an easy way of ensuring that from the husband's side, the wealth he's created goes to the wife, and the wife then makes the point very clear upfront along with the husband's will that post her everything goes to the son in her will.
Okay, all right.
Sorry, I'm going to add a complication here. Just because, in the interest of complete disclosure, it's that works as long as the wishes are not changed post husband's lifetime.
Okay. No, because the reason for asking this question is this is the major problem that we have in the civil disputes today. At least hundreds of cases are there. Like after the head of the family dies, the will goes to the children, and the children don't take care of the mother.
No, you're absolutely right. What typically what I have seen, at least in my career, right, is that typically, like Prashant said, if a will is written, usually the first beneficiary to the assets are usually spouse.
Okay.
So either he mentioned, it's like a mirror wishes, essentially to say all my assets goes to my spouse and vice versa. If both of us are not around, then it goes to children. To ensure your both, first you guys are the creator of the asset. You should have control and access over it for your lifestyle. Thereafter,
Okay.
the children can get it. Very simple.
Okay. Yeah, got it. Yeah.
Nikhil,
Thank you.
for the condition you are talking, right? Conditions of the will. Can you make like that instead of going a number of edits? Shall we write the will like that until I am getting 50 years old, or my children gets major? If that will be like this. If after the 60 years of my age, if I miss, then the will be like this. We can make like that condition inside the will.
Your will can perhaps have those things.
Yeah. Okay.
You can say that if I pass away before 60 years of age,
Yeah.
then my assets needs to be distributed XYZ. If I pass away after 60 years of age, my assets needs to be distributed in XYZ format. That's your wish. You can definitely capture it.
Okay.
But my point was to say that once the transfer happens, you can't have more control over those assets.
Yeah. Actually, it becomes her property. Then she has to take her own decision.
Yes.
Okay. That's Nikhil, what about the
We'll have
regional
more
language
questions
option?
answered. Yeah, please go on. Yeah.
Listen, the last question. The app does not have a regional language. So many people, if you want to motivate or encourage people to create a will, that should be also regional language, right? Then only if I say someone I'm actually from village background, if I say to one of my friends there to write a will, he may be right, but if the app is on English language only, then he could not understand, then it will not be valid, right?
Yeah. So, these are baby steps, right? First
Yeah.
step is to create this in English and perfect it at some point, and then start seeing which is the more prevalent regional languages and start introducing those.
Yeah, okay, okay.
In the future, you'll definitely have a different language for this, not to worry. When in the future, I don't know.
Okay, the question I can ask in a different way. Like someone write the will. So consider they are very old now, around 66 years old. Their kids
Right.
are challenging the will in the court that my father does not know English. So he write a original will, then will not accept. Does that can happen?
It can happen. In those cases, what we ideally say is that, one to, couple of things that we try and do from making the will more robust is to have a video recording. In this case, specifically to ensure the video recording is taken care of. One, if you don't do that, we usually take a declaration from the parent to say that I've heard the contents of the will and I understood, though it's in a different language. That's an option so that it's protected. Second, if you were to take a video recording, you could read out in English and again say it means that so and so in your regional language. Let the recording happen. The parent understood exactly what is there in the regional language, and then they're signing the document.
Okay.
That's a good way to kind of ring fence from any potential challenge tomorrow, because you're reading line by line to say, I, Nikhil Verghese, aged so and so, and converting that immediately in say Tamil or whichever language.
Okay. So that video can be uploaded on the app?
Yes, you can.
Okay. That's good.
Hope that answers, Lakshman. And your feedback on the will itself being in regional languages is taken. As Nikhil said, that's work in progress from our side. Mani, we can move on. I think we can move a little quicker on some of the slides because we'll keep it more question and answer based. So these are just some facts. A whooping 1,50,000 crores lies in Indian banks and insurance because PF is unclaimed. People do not know about what insurance an individual has taken. A disclaimer, but one of the reasons why companies like LIC really thrive and survive. So we know that many of our assets that we build, our future does not even get to be aware of those, and that is why that huge a number, almost 25,000 crores of that lies in PF. So as an NRI crowd, in case you have your PF accounts, old ones that are in place, one segue to this point is to let you know that please ensure that you do your nominations and ensure that your PF account is well documented to ensure that we don't add further to that 25,000 crores. Some other statistics: almost 76% of litigation is property and family disputes. I think Ram or Raghavan, I think, mentioned some of those examples, and it takes more than 3 to 4 years at least to complete all the formalities post death if a formal will is not in place, right from legal heir certificates to succession certificates to running from a tahsildar to a kata office. So we all know the challenges in getting what is rightfully ours in the absence of COVID. We can move on. Nikhil, would you want to just take it from here? Just a few more slides, and then we can keep it again open to Q&A and show them the yellow app.
Sure. So essentially, if you look at, from a creation of a will, we did speak about multiple things, but why is it important and what is a will? Will essentially there's no format, fortunately or unfortunately, for will in India. And if you look at creating a will, it's more about documenting your wishes in terms of what your assets are and who do you want to transfer those assets, and that wishes being documented is what is legally called as a will, right? And that's the simplest way of explaining what a will means. And to make a will, what are those? Why would one need to look at it? Is first and foremost some of the aspects that Prashant did talk about in the beginning. Is the fact that there are various implications of not having a will. One being the fact that if you don't have a will, your personal laws are determines how the assets needs to be distributed, and that may not be your wishes. And how to overcome that is by creating a will, which overrides interstate succession being triggered. Second, of course, more than that, this is the first and foremost important step in an estate plan, because you can have multiple tools for creating estate plan. We did touch upon briefly about trust, etc. Those are all tools that are available, but at any point in time, will becomes a basic document that needs to be there. And over and above that, if your wishes or your objectives are not met, is when we look at more advanced documents. Could be a trust or gifting or etc. Whatever that you want to look at, but will always comes to the picture no matter what, because there'll be some or the other asset in your name that needs to still pass away, rather passed on to your beneficiaries, and for that reason, will is a basic document that needs to be in place. Of course, avoids litigation from a family standpoint and helps in smooth transfer of wealth to next generation, because your wishes are very clearly laid down, and that becomes your wishes being clearly captured and assets gets transferred as per those wishes. And more important aspect is not about creating the document as is, but also capturing all your assets, because asset discovery is the biggest challenge for loss of asset in transmission, because families will not have complete picture of what all assets you owned, and that's where the 1,50,000 crores of unclaimed assets come into the picture. And how do you avoid that is create a robust will which also captures the list of all your assets, not with values but with identification of what your assets are. And we did touch upon mitigation of potential family liabilities by making your wishes very clear. Liability can in some way be avoided. And very important aspect which often gets ignored is who is the guardian to your child, right? Of course, by law, father is the first natural guardian, thereafter mother. But if what happens if both of you are not around? Who should be the guardian to your child? And who are, other than parents, know that the right compatible person for your child? If you don't, then the courts determine the guardian, and that may not be the right answer for your child because you know the child and the custodian better, and therefore you nominating your guardian in the will becomes utmost important. And of course, we did hear about this in the conversation already, but if there are situations where you don't want to provide certain assets to somebody, or you want to specifically exclude someone from the whole beneficiary list, that is something can be possible only if you write a will, because the law otherwise gives a broad distribution fact pattern, and that may not be a wish. And if you want to exclude for various reasons, it could be for reasons that somebody, there are two children, one is doing well and the other is not, and therefore you want to definitely ensure the other is also compensated. You may want to do that, or for whatever reasons. It could be a personal situation, emotional or family dynamic situation. For whatever it is, if you want to exclude someone legally, who's potentially a legal heir to the property, then you need to capture your wishes accordingly. If you were to move on to the next slide, is very important slide on some of the myths and facts about.
Hey, hi. If like moving to the next slide, can I ask one more question just
Sure.
related to the same topic?
Sure.
Yeah. Okay. So can we now imagine there are 3 children in the family, 1 male and 2 daughters. Can the father write the will that all my property should go only to my son?
Yeah.
Okay. So if he has written like that, can't the daughters challenge it?
No, they could challenge on what basis? See, if he doesn't write a will, then everybody has equal access.
Okay.
But if he writes a will,
Okay.
it would mean that he has captured his wishes, saying all my assets needs to. Now, daughters can definitely challenge on what grounds? There are 2-3 grounds on which the daughters can challenge. One, to say that the will was not a valid will. That needs to be proved. Second,
Okay.
the will was not written when the father was of sound mind. That needs to be proved. And the third, to say that the son has actually created this document and it was not the father who did it, or the father was forced to do it.
Okay.
All of it needs to be proved. The ground can't be just because they didn't get a benefit.
Okay. So simply put, if the father is in good senses and he wants to give all his property to his sons only, he can do that, and legally he has all the right to do so.
Absolutely, unless it's a not a self-acquired property and falls within the definition of ancestral property.
Okay. No, like all the property are earned by him. In that case,
Then
he can do that.
It's his complete prerogative for him to decide how he wants to deal with his asset. He can even decide to not give to sons and daughters, but only give it to a charity. That's also possible.
Okay, but if the will is not written, the daughters can still
They have equal right
can
over the
claim it.
property.
Okay, all right. Thank you very much.
Nikhil, there is one more question on the same topic. On the same.
Sure.
It will be right. Like I heard or read somewhere that in a will we can add a clause that once you complete the will, you can add a clause that says this can't be challenged in the court. Like you divide the property for three children. Someone is not satisfied, and they want to challenge it at court. In that case, we can add a clause. If anybody challenge, then they will not get anything from this. So other will share the property. Like that can be added.
It can be done. The only thing it can be done is that if they challenge and lose. Just because challenging, see, when they're challenging the validity of the will itself.
Okay.
Right? Just because the clause is there, it doesn't stop someone from challenging. But if the will is valid and the challenge does not sustain in the court, then definitely the person can get excluded. We look at two options here. One is to say that because you're challenging, there is time and effort spent in the court.
Yeah.
Right? somebody has to bear the asset. It can perhaps come from that person's share only and not from the others. Second, more regressive process could be to say that the person, if he challenges and loses, will not get any share in the property, and the balance beneficiaries get his or her share.
Okay, like that.
Yeah, it's a possibility. You can write it out. But in that, for that to sustain, the challenge has to, once challenged, the will has to be upheld as valid will.
Okay, I got it.
Yeah. Should we move on to the slides?
Nikhil, the will has to be registered in the registrar office, or just we made it and like keep it in ourselves?
That's one of the myths here. We'll address that.
That's
Let me
the
pick that.
4.1. Yeah, so we right there. You can see that on the slide. So yeah, Nikhil, over.
Let me pick that itself to say that by law, under the Indian Registration Act of 1908, will is not required to be registered. It's not mandatorily required to be registered. But as a good practice, at least when there's real estate involved, it's good to register the will.
Okay.
Right, and that's the myth, one of the myths that we need to bust, because everybody talk about will needs to be on a stamp paper, it needs to be notarized, it needs to be registered, which is all completely wrong. It can be on a plain paper. There are cases where it has been upheld when the will is written in the back of a bus ticket, very honestly. Therefore, anything, like I said, there's no format for a will in India. But like I said, if there are real estate coming into the list of assets, then it's a good recommendation to have a will registered as well. Now, if you look at other myths here, first one, if you look at it, is nomination. Typically, everybody has been told that once you put a nominee for your asset, they become, and that's a good succession plan, and they can get access to the asset. The answer is yes and no. They do get access to the asset, but they're not the owner of the asset legally. The owner of the asset essentially is the legal heirs again. If you don't have a will, when those assets though go to the nominee is only a trustee of those assets, and the legal heirs have complete right over those assets, and the legal heirs can claim those assets from the nominee. That's the law of land, except in case of life insurance.
I'm sorry. Hey, sorry, Nikhil. This is Raj.
Mm-hmm.
So just now you were mentioning about the nominee, right? So what if a husband nominate wife, and after that husband pass away, and in that particular, for example, in the insurance situation, right? If they get a lump sum, the kids also has equal rights in the lump sum, right? That's all comes in real estate, right?
Not for life insurance.
Right.
For life insurance, if you have nominated only spouse, then it goes 100% to spouse.
Okay, so the kids don't have any because they also legal hire now.
No,
does it comes in real estate, or it's just
no? It doesn't. It doesn't.
Great.
Life insurance is an exception to this nomination rule that I spoke about.
Great. Thanks.
But say if it's a bank account, right? Say you had FD or you had investments. There you have nominated spouse as a nominee. There, when the husband is no more, a wife along with children, and depending if it's the person who wrote the will, or rather the person whose assets we are talking about, if it's an Hindu male, mother, spouse, and children have equal rights over those assets. Those spouses the nominee.
Great. Mothers and kids and grandkids?
Not grandkids, only kids.
Great. Sure. Thank you.
So there are two categories. One is class 1 heirs and class 2 heirs. The ones that we spoke about form under class 1 heirs. Thereafter, class 2 heirs comes into the picture. That's an order of priority. It goes to father, grandkids, all of those comes into the situation.
Thank you.
Now, moving on, typically there's a misconception that, what is there? Why do you need to capture wishes? Everything goes to my spouse, as an example, or it goes to my family. Again, I think by now you've understood that it doesn't. And that's something which we definitely need to bust as a myth. And therefore, creating a will becomes very important to capture specifically what your wishes are. Usually, the third thing, if you look at as a myth, is that or the thought process is that will needs to be created only when you're reaching age where you need to create it. And when I say reaching an age when you need to create it is a subjective term. Essentially, at old age is when you need to create a will, or when you're unwell, or you're essentially to say when you're closer to your deathbed is when you need to write a will, which is a completely notion that something that we want to bust as a myth here, because you don't know, life is uncertain, it has to be created like how you get a life insurance, right? You don't get a life insurance at situations like this, but you get it at your young age, because it's more of a safety bracket that you create for your family. And there, if you're talking about a safety net for your family, essentially it's to say a corpus goes to them. If you're not there, it substitutes your incomes. But what about the assets that you've created? That also need to go to them in a simpler fashion and seamless fashion. And that's why will needs to be created not when you're old or unwell, but should be something as part of everyone's financial planning hygiene. And that's why the initial questions that Prashant raised becomes very relevant. The third aspect of will is necessary only for the rich. I think why we started the startup kind of gives you the answer of why this is important, or why this is a myth. The fifth myth that we're talking about is a will needs to be created, or needs to be made only by a lawyer, and once made cannot be changed, is also a myth. Anyone can create a will. There's no format, like I said, for a will. What you write is your wishes, but more than that, how to make it more usable, more reliable, more robust is where we come into the picture. But that said, once a will is created, it is not a constant document. You can update any number of times. Today, we had another conversations on similar line. They asked, what should be the right timing and when should I be updating my will? It's a more objective statement or a relative statement, because you could have created a will in the morning saying all my assets goes to my children equally. Evening could have had a fight with your one of your child and say, I want to exclude you and I want to update it, right? That's a possibility. And you can update your will at any point in time, but ideally you should look at updating your will when there's a change in the family situation or there's change in the asset situation. That should kind of get reflected, and to capture your right wishes, that's when you need to start updating your will. And nothing is constant. Until any moment you can keep updating your will. The sixth
quick time check, and considering it's a closed group, I'm taking the liberty of extending this about by 15 minutes or so. I'm hoping all are fine, because I think we can keep it freewheeling and more questions coming through as well. Mani, I'm hoping that's fine.
Yeah.
Perfect.
Great. So I think the sixth myth also we kind of address. I lose control over my assets. I think we spoke about it. Don't need to reiterate that aspect. Will becomes very relevant in holding control, and you lose control only, or rather the assets gets passed on only post your lifetime. And we spoke about registration, nominee, stamp, etc. Making a will is time consuming and costly exercise. I think we have an example already here. Mr. Lakshmanan has already created his will, and he has done it through the app, and it's pretty seamless and fast. Yeah, moving on to the next slide is more on the aspect of how a will can be made robust. Definitely, there are two aspects here. One is to say what are the must-haves in a will, which essentially to say that the person creating the will should be 18 years plus. There should be an asset register which captures your list of your assets, not by values but by identification. And your wishes should be unambiguous. That we have seen situations where people have written a will saying my executor will determine how the assets needs to be distributed. That's the worst way of creating a will, because you have created a will which is a clear recipe for dispute. You need to capture essentially what your wishes are in black and white, to say if I have a jewelry, I could perhaps say all my jewelry goes equally to my children. Then question comes saying, how do you divide this equally? The other option is to say jewelry 1 goes to child 1, jewelry 2 goes to child 2. That way the wishes are very clear, and if that something can be done, that's always a better way to kind of address any ambiguity and avoid any kind of somebody else interpreting your wishes rather than you clearly laying out what your wishes are. The third point on signing of the will by the testator along with 2 witnesses, minimum 2 witnesses, is a mandatory requirement under law for your will to be valid. And more importantly, if the witness should be not conflicted for your will. When I say not conflicted or not dependent or interested on your will, essentially to say that your beneficiary should not be a witness. Your witness should essentially be someone who has no benefits or roles other than being a witness in your will. And the fourth aspect, which is very important for a will to be robust, is or one of the must-haves, is to have a prudent choice of an executor. Now, what is an executor? What is the role of an executor? Is essentially, executor is a person who post your lifetime ensure your wishes are taken care of, or wishes are given effect to. Now, your executor could be your beneficiary itself, or it could be somebody else who is very near and dear to your family, who you would trust to ensure that all your wishes are given effect to. Now, some of the good to haves aspects in your will is, one, we did speak about this earlier itself, to have a videography or a video recording of your will, essentially to ensure that you read out the will along with your witness and you signing the will. That becomes a good proof if tomorrow the will gets contested. But that said, does the witness need to know the contents of your will? The answer is no. The witness need not get to know the content of the will. All that they need to know is that, or they need to see, is that you have signed the will before them, and that is something which gets questioned if at all tomorrow the will gets contested. And one important thing in terms of video recording, it should always be a one single recording and not multiple videos getting stitched to make one. The other aspect of good to have, aspect to ensure your will is more robust, is to have a doctor certificate. Now, again, we spoke about this earlier, essentially to say what are the ways in which one could contest your will. One of the grounds is to say that the person was not of a sound mind, and your doctor certificate comes in handy if that becomes a contestable point, because on the date of you signing the will, you also have a doctor certificate which says that you are of a sound mind. And the third aspect, which again is a recommendation, more so if it becomes relevant when you have a property as part of your wishes that needs to be transferred. Otherwise, it may not be very relevant to have a registration of your will. Moving on, I think it's more about us. I think Prashant did spend good amount of time in terms of explaining who we are. But simply put, our DNA kind of starts from being estate planners and using technology as an enabler to provide the service to everyone and not only for the rich. Essentially, what we have done today is using the technology platform, you can capture your wishes in a very seamless fashion, and the output is 100% legally valid once you sign and along with 2 witnesses. We have kept it as seamless and user-friendly way of creating this, and the app itself is very user-friendly, and since it's through an app module, you can always continuously update it, and whenever the delta reaches where you want to create a new will, you can always generate one. We have kept security as a very big aspect on the forefront before in terms of this will, and we have taken all banking level security protocols to ensure data is completely encrypted, and we at the backend don't need to read these data. System generates the entire document, and we don't manually intervene. And more importantly, we charge a fee for the services, and therefore we don't need to harvest your data. And the other 2 bullets essentially here is more on the service arm that we have, which is one, of course, is creating the will, and the second is we wanted to provide a 360-degree service for our clients. And essentially, once you have created the will, you'll also need services in terms of saying, especially for folks like you all, because you are out in an offshore jurisdiction, but assets are in India, but you may not have the time and or the knowledge to ensure transfer of assets happens in India, right? And what we have done is we have created a service arm as part of this whole offering to ensure we act as a single window solution for transfer of assets when a demise arises. Whether you have a will or not, we can help you out. But with the will, it becomes even more handier because the process becomes much more seamless. And here, what we offer is if we go to slide next 2 slides, that's where we talk about a little bit more in depth on what the product is in terms of creation of the will through the app. And the second service model that we have has 2 pricing modules. One, if you have created if you have used our platform to create a will, you also have an option to create a subscription, where depending on your age, you can have a subscription, and when a situation arises, your family can use the entire fleet of yellow agents on the ground to ensure assets gets transferred seamlessly. Families need not step out of the house unless they are really required to. But whether or not you take that subscription, you can always reach out to our team when an event arises for helping with asset transfer, and that would be on a case-to-case basis. Depending on complexities, we come back with what the right pricing should be and take it forward from there on.
Thanks.
I think that's broadly it. From a pricing standpoint, we have kept it as affordable as possible for creating the will. It's we have priced it at 2,500 rupees, and for the initial set of users, we also given unlimited updates. Therefore, this becomes the only cost. And with respect to the post-demise transfer of asset services that we're talking about, that's it's a more dependent on what your age bracket you fall under, and if you were to take a subscription. Otherwise, it's more cost and effort basis, essentially depending on where the complexities are, whether you have a will, whether you don't have a will, where the assets are located, and all of it is something which we factor in to provide a right quote to help with the overall transfer of asset process. But in that whole overall services, we ensure all assets within the jurisdiction of India is taken care of, not offshore assets.
Nikhil, are you recording the particular, suppose I have one land, okay, in some other districts. Are you recording the particular Google location also, or only the survey number and all, just you are recording that?
It's survey number and address. But in the future release, we do want to put a location pin.
Okay.
Again, all these will be optional. See, what we intend to do is have certain mandatory fields, because that becomes relevant for basic stuff that should be known for family. But beyond that, some of the optional items will be there, which it's up to the user to see how much information they want to pass on to the family, right? The more the information, the easier for them to get access to
because
data.
if you provide the survey number, then the new person, it's very difficult to find the particular location. They have to reach the village VO, and like it's a process, kind of process.
It is a process, but end of the day, even if you know the location, from a transfer standpoint, it's still the survey number which becomes very relevant from the village panchayatas. At least today, what you have done is, we're enabling users to at least upload one relevant page in the title deed, which is your the page where it talks about north by so many square feet, south by, west by, east by, whatever those specifications come into the picture. At least we are asking users to upload that, if you not mandatory, again optional. But we've tried to put in aspects that are more relevant, and these are more nifty features which will come into the picture, including the question of saying where have you saved your property title document as well, right? That's also important. Those nifty features will come in future, but for the time being, what we have is at least for one to get the business done in terms of creating the will. We have kind of rolled that out now.
Mani, could you play that video link? I know Manjunath has shared two of those, but I've also shared one with you. Just a quick video for all to.
It's a quick 2-minute video, which will give you a sense of how through the app you can create our will.
Shall I play?
Yeah, you can. Great, thank you. And my only rider for this group is that the free delivery of will not apply. That's only for Indian address.
Yeah, but that said, you can take the print and have your witnesses sign it. We've also shared some information on chat. My colleague has given you both the Android as well as the iOS version of the app. As Nikhil mentioned, we've made it very, democratized it for any and everybody to make their wills. It is the first will at a price of 2499. For the first 5,000 users, you also get unlimited updates for life, and you may use the code launch20. I think Lakshman used the same. You will get a 20% discount as well. So please do feel free to download and try the app. And as Nikhil mentioned, there's no such thing as a perfect will. It's always good to start, right? So please do have a look at some of your key assets, beneficiaries, guardians for your kids, and have your first will done on the app. Because rest assured, you also do have unlimited updates for life, so you can always go back to the drawing board and edit as required. But to get your first document going is important. So I'm hoping that all of you can try the app either on iOS or Android and go through the process. You may also share your feedback with us, considering Mani and Lakshman and all of them are known to us now. Look forward to you having a quick utilization of the app, giving your feedback as well through any of them. And I am available. I'll just share my official ID and my number as well. You may also reach out to me directly.
And one a quick point in terms of what Prashant mentioned in terms of creating your first will quickly, and then you can always refine it, better it. There's one specific clause, if you see in our app, you'll see that in the distribution section called as residuary asset. That will kind of take care of all future assets, whether you have captured now or not. You just need to capture what your wishes are around those future assets or residuary asset. And that, even though your assets are not completely captured, that will ensure whichever those assets which are left out or that you capture in the future will get addressed. But from a family's interest standpoint, you can go back, update the assets, keep the asset register up to date, and whenever you need, is there a need for you to think you need to create a new will and update your existing will, you can just generate the will, and if you're part of the 5,000 users, then you don't need to worry about a cost in terms of generating new wills any number of times.
Nikhil, can you show some draft like the created will with the highlighted?
Unfortunately, no. Because that's sensitive data and we don't have access to any of those data. That's the worst part.
So how the draft will looks like at least the user can see how it looks like.
No, so
like kind of terms and conditions, any clauses, something like
no,
that.
So see, the whole idea, Mani, is that the legal aspect of it is something that we have taken care of. What I can assure you is that you'll get best in class or a top notch language that is coming your way in terms of legal aspect of it. What we have done is we have kind of made it as watered down but very clear for any layman to understand, because this is not like an agreement where you need to use too many legal jargons. But we have made it as watertight. Though it's watertight, it's as much as layman terms that's used, so that the executor may not be a lawyer, but the executor should know exactly what this means. And to that extent, it's a very simple language that will be there. But from a creation of the whole process standpoint, you are not looking at any legal languages while capturing your details in the app. When you generate the will, the document comes to you.
Yeah, Nikhil, I will add something here. Manikandan, the video what they shown, right? That is the app. That is how you enter the data.
Want to see the output of the document, like to hiding the sensitive data, how it looks like. So I'm curious to see that.
See, once we start to fill the app, right? So basically, you will add the beneficiaries and the executor, everything, right? Once you done fill everything, the document will send to us an email also.
No, that I understood. I saw in the picture, but I'm just curious to see the output of the document. Anyway, let it be. No problem. Any doubts, colleagues?
So- No, I'll tell you what happens, Mani, and very honestly, this is something which I always avoid, is that once you see a format, no, you'll try to fit your situation there.
Oh, okay.
And it may not be the right thing that works for you. Your situation will be totally different from what Mr. Lakshmanan has, right? So it's better you don't go with the mindset that, okay, this is how my language should read. For each person, the language changes, and that's why I don't have a standard document that I can give you. But depending on what options you choose in the in the app, the language in the will kind of changes.
Okay.
Sorry, Nikhil, I have one last question.
Sure.
Yeah. So, I mean, this is regarding will also, right? So, will writing. So, what if, if I'm writing a will and I'm nominating, I mean, I want my assets to go to my wife, and our marriage is not registered in India. So, how it will work?
So you're not assigning to say it goes to my spouse, right? What you're saying is that it goes to Mrs. So and so.
Right. No, it's my spouse, right?
No. So when you from an ease of thing, I'm talking about spouse. But you're actually, when you say spouse,
So you're going to name the person and everything.
you're naming the person along with the person's date of birth.
So
and
you don't need to show any evidence of
Nothing.
marriage cert or anything, right?
See, when it comes to writing a document, if you don't write a will, that's where the relationships needs to be proved. Right? Once you've written a document saying that it goes to XYZ with identification, then that becomes the person who needs to get it, no matter what the relationship could be, right? I'll give you another example. Your wish could be that it needs to go to so-and-so person. Now, this is very common. You could have even had separation.
Right.
But for whatever reason, you will still say, no, I wish this asset goes to that person.
Right.
Right? Which in your will could still say to my spouse so and so. The relationship could continue to be spouse, but I've identified the person saying it's Mrs. So and so.
Great. Okay.
That becomes relevant. We go by names and not by relationships, very honestly.
Thanks for the clarity.
Nicola, I just see only one more point to be added here. While creating the will, I was seeing that one good thing is the executor. The executor does not need to be a beneficiary. So we are entering the executor name, phone number, email address, everything, and he will also get notified once we create the will. So he may be our close friend or who will be our relative who will be in contact with us. So that person, particularly, we know everything what we have. Maybe someone we strongly believe. So that person, if we get notified that we created a will through this app, and we will also inform him that I informed him in my case that I created an app in this will, so you will get a message. So nothing to worry, but be safe. This is the actual also reality. You have to take care of these things. Also, he does not know what I read in the will. Even my witnesses, we does not need to know it also. I can get in the last page of the will. I can show to my witnesses. They will sign those places. Then we can attach with our will, and we can scan it, and we can upload in the app itself again. So it will be registered from their side. So it will be legalized document. So these two places in common, then our will be very secure, and we also feel very safe.
Right. No. So what happens here is that this feature is getting live, as in we are building it out as we talk about it. Is that since you notified your executor, the document that you have also has a QR code in the front. I'm not sure if you have observed it.
Sorry.
In your first page, in the first page of the will, there is a QR code. Have you seen it? So essentially, there is a QR code that kind of enables when the situation arises, they can scan the QR code to trigger something we call internally as a demise trigger, where if they provide complete details to us in terms of a death certificate, etc., then once it is validated, we push the entire asset details to your executor. from the app.
Okay, that's great.
So therefore, whether you updated your will or not, if you have updated your asset register, rest assured the latest asset register goes to your executor and beneficiaries.
Okay, Nikhil, thank you.
So that will happen. Of course, the functionality, some of it is still not active, but over the period that will get activated. And therefore, your executor, once you're nominated, and that's a good point that you brought about, and this is what we recommend everyone also to do, is at least notify your executor, so that they know that you have created a will, and he or she is the executor, because they can, one, accept the fact that they want to take up this role. Second is that once any situation arises, they know where to go to, and they will have all the instructions that is required in terms of how this needs to be done. And they perhaps also can reach out to us and our team for any further clarity, what instructions, etc., in terms of anything that needs to be done.
Any question, Vipul?
No, Mani, thank you. I was listening and it sounds so informative actually. I read this book you recommended, and it is much more than that book.
Thanks for that, Vipul. If we could cover something in an hour, I mean, that's real nice of you. Thanks for the acknowledgement.
Ravinder?
Yeah, Mani, I carefully gone through the entire presentations, and really it was very informative. So far, it is clear, because for me this is a new chapter, and here is mentioned that sometime we will untouch with this topic due to the given reason that why we have to do this, why we have to open the discussions on the chapter. But now for me it is more informative, and yes, I will start to think on this direction. Honestly speaking, so far I didn't. But yes, the session gives you information and that how it is important, how important it is. That absolutely fine.
Yeah. And
so yeah, so far no question there.
It is a last part of the personal finance, but no one is talking about in our family, because we have a lot of hesitation to talk to our fathers and mothers and sisters. But it has to be broken, like at any point of time. So it is a first step. We are just moving ahead. So let us try to penetrate the knowledge to others also. Let us hope we will try to do that. So any other question, then they can answer, unless we can close our presentation.
For me, no specific question so far. Yeah, thanks.
So thank you, Nikhil and Prashant, and my friend Manikandan also, who is generous doing all these things always. For many people are getting very good support. And thanks for the wonderful presentation, Nikhil and Prashant.
Thank you so much. I think more than we presenting, I think it's great that you guys are taking these initiatives to spread the awareness. We could be in a way a catalyst in presenting this, and more than happy to do many more sessions in the future if there are more audience to listen to us.
Prashant, I'm putting request. One day we can try to talk at least half an hour session in Tamil, because the language, the regional language must for our people. So we'll try to cover at one day half an hour, 45 minutes. So you can support.
Not a problem at all, man. Done.
Yeah, thanks a lot, guys, for your time with us. So Nikhilji and Prashant, thanks a lot for your time.
Thank you. Thanks.
Our pleasure.
Thank you, Nikhil and Prashant. Thank you so much for the informative sessions.
Thank you.
Have a nice day. Yeah, bye-bye.